Here are two common situations at workplace that involve a psychological or a psychiatric disability issues that are in some way similar, yet there is a key distinction between two of them that would affect an employee's rights in each case under ADA and FEHA disability laws. In one case, the employee would not be entitled to an accommodation and would not be considered disabled, while in the other case, he would be considered disabled and he would be entitled to an accommodation. So let's talk about the first case where the employee would not be entitled to an accommodation. Let's say you develop anxiety, stress, depression, and related symptoms at work, and you go on medical leave or disability leave. And then at some point when you're ready to return to work, your doctor writes you a release note where it says that you're able to return to work to your full job duties without restrictions, except the doctor recommends that you work for a different manager. You present this note to your employer, and the employer can, if they want to be nice and if they want to be helpful, they can place you to work under a different supervisor, but they don't have a legal obligation to do so. Why? Because if your note says that you can work and you can do everything without restrictions, except you have an issue with the manager, you're not considered disabled under the law. And if you're not considered disabled, then the obligation to accommodate you is simply not triggered. So the employer will not have to do that, and if they say, you know what, we don't care about your doctor's request, you're healthy, you can work, you have to deal with your manager. If you have problems with him, you have to work it out. We're not going to transfer you to work under a different manager. This generally will not be a violation in this type of case. This scenario is very different from a situation where the employee is taken off work because of the extremely stressful environment at his workplace that led him to develop serious psychiatric or psychological symptoms, and where the only way he can come back to work given his condition is if he returns to a less stressful work environment. Now, by stressful, I'm not talking about common trivial things such as personality conflicts with coworkers, being micromanaged, not receiving fair performance reviews, maybe being involved in some type of office politics or some other type of office drama and so forth. This type of common stuff would not be considered stressful enough for this second scenario. It has to be something much more egregious and more significant. And one common situation that often arises is in the education sector. Imagine a situation where the teacher of a school district who works at a violent school where he witnesses fights, maybe he witnesses how children bring guns to class. He develops extreme anxiety and depression as a result of what he sees at school, and he's placed on medical leave. And then at some point his doctor would write a note that says, Mr. Such and Such is suffering from this type of condition, but he can return to work to his regular job duties as a teacher, except he has to be working in a less stressful environment or less violent environment. In this type of situation, if the school district has vacant teacher positions in other schools, in other less violent schools, the positions for which this particular individual, this particular teacher would be qualified for, that district has an obligation to inform the teacher who returns back to work of those positions and allow him to apply to those positions, and also provide him with preferential treatment over other applicants in order to be hired for those positions to work at a less violent, less stressful school environment. Now, why is this situation different? Because in this case, the doctor doesn't say that the employee is fine. The doctor says he has problems. He cannot work in this environment because of what he witnesses. It aggravates his symptoms. He needs to be placed in a different environment where these symptoms will not be aggravated. So, again, in this situation, the employer will have an obligation. And if they say, no, we don't care, we're not going to look for vacant positions, or we have positions, but we don't want to bother, you have to go back and work where you are, then that would be a violation of disability laws for which that employer can be sued and be found liable for, again, under Americans with Disabilities Act and also under the California FEHA, which is Fair Employment and Housing Act. Thank you.